Paul Foster-Bell.
Mana whakaua. Thank you, sir, for the opportunity to speak in this third reading debate of the Exclusive Economic Zone and Continental Shelf Environmental Effects Transitional Provisions Amendment Bill. That's quite a mouthful. So I'd like to begin by thanking the member who just resumed his seat for his gracious comments about the work of the committee. And if I can add also my support for what he's said. It's a great pleasure to work under the chairmanship of the member for Continental, Mr Scott Simpson, who does, I think, approach these matters in a very cross-party and multi-partisan way to get the best possible results, putting aside the politics of these things. So this is a very important issue for New Zealand, and I have to disclose, I suppose, on the record that I did my Business Parliament Trust work placement recently with Todd Energy, a very fine company, a New Zealand-owned business, probably the largest, actually, New Zealand-owned private business operating in this country. And they've been functioning, producing energy in the Taranaki region now for 40 years, and they've done so in a very safe and effective manner, environmentally sustainably, in terms of certainly not producing any spills or in environmental degradation, but also with great regard for the safety of their staff and their people who work in their facilities. So this is a very important issue for New Zealand, because that is a field which produces 20% of our natural gas supply. And this isn't just what we cook with and perhaps heats our water for our morning showers if we use gas as a consumer. But whilst doing my placement with Todd, sir, I had the opportunity to see how else the gas is used. It's exported and is a valuable export commodity for New Zealand. Not only does it earn us those export dollars, but it often is shipped up into the Pacific and to places that don't have the same energy resources that we do, and is very important for those small economies. But also it's used in the peaking power industry. So they operate gas turbine power plants which in situations where either we have a drought and insufficient water in our lakes to sustain the generation of hydropower, or in other times when there's a high demand, such as the cold snaps we've experienced over the last few days, they will use natural gas to fire turbines and supplement the base load that's produced by more sustainable means, such as the hydro and geothermal plants in New Zealand. So it is a very important issue. So we've had some contributions from across the House which I think actually necessitate me putting the record straight. And I don't want to be ungracious myself, and I welcome the change of heart, or at least coming to the senses of the Green Party in voting for this bill. And I also welcome the support from Labour and New Zealand First, in fact the universal support of this House for this piece of legislation. But there have been some comments made in the debate that do necessitate a response, I believe. Firstly, from Mr Nash. I acknowledge Mr Nash's expertise in this industry. He's worked himself in the petrochemical industry. But Mr Nash accusing the government of making sloppy amendments, or in fact amendments to sloppy legislation, is a little bit rich, given that was a government which passed the Police Act, which required an emergency, extraordinary urgency to correct a drafting error which had led to a large number, dozens of New Zealand police constables not being correctly sworn, and potentially could have had very grave ramifications for the administration of justice in New Zealand. Similarly, Mr Hughes, Gareth Hughes, when he made his contribution, claimed that we have the fourth largest economic zone, exclusive economic zone in the world. Now, sir, this is not correct, and just consulting publicly available sources on the internet, you'll see that we're the 8th or 9th, depending on the definitions used. Unless you want to include the realm of New Zealand, that is the small countries which we are in free association with, Niue, Tokelau, the Cook Islands and parts of Antarctica. And I think it would be a far cry for the Greens to be embarking in that sort of imperialism where we would want to claim the resources of those countries with whom we have close relationships, but we don't purport to own what is under their seabeds, or in fact the fisheries and other resources that go with that exclusive economic zone. So I think it is important to correct those issues. Sir, Shell Todd the first and probably foremost company when it comes to passing this amendment in that they had a permit which expired on the 27th of June. Now, it is true that that situation is less problematic now given that they have been given an approved permit. But there is a matter of principle here. We came in as a government where there was no protection whatsoever for an exclusive economic zone. We had 40 years of oil companies and gas exploration in New Zealand with very limited controls. And now I'm quite proud to be part of a government which has brought in comprehensive and consistent controls and process for registering and seeking permits to be able to explore and extract petrochemicals and gas. And it's actually probably should be unsurprising to us with such a substantial and also new and innovative piece of legislation that there will be issues that need to be amended. And this is a correctly named bill in that it is a transitional provisions amendment bill. So I think it is Shell Todd that is the first beneficiary, if you like, of this piece of legislation, but there are several other companies that have permits expiring out through the 2020s, for which this bill was also required to give them sufficient time to lodge their applications and have them reasonably heard, and to give also our environmental protection agencies sufficient time to review those applications and make sure they're making a well-advised and fair decision on those particular cases. In the committee, and I think other members, Major Mark referenced this, we did hear differing views, and my personal view was that an application period by which a company must lodge a consent for their marine permit, I thought 6 months was a reasonable time. That was my personal view, and I particularly favoured 6 months because it was in line with the Crown Minerals Act. I thought consistency between exploration onshore and offshore was fairly important. But as Mr. Mark referenced, we are a fair and reasonable committee. Our ears were open. We listened to the arguments that were made. It wasn't my personal preference, but we came to a timeline of 9 months by which that application must be lodged prior to its expiration date. So whilst my preference was 6 months, I think 9 months was a good compromise. It's something that the companies will be able to manage and ensure that they continue to function producing that valuable export commodity and energy for the New Zealand market. So as the law currently stands, were we not to pass this, those current applicants and operators who are applying for marine consents would find themselves in breach of the EEZ Act if they continued operating beyond the expiry date of their permits under the Crown Minerals regime, the previous regime, and even if there was an appeal in process. And to me, sir, it strikes as something that's manifestly unfair. If you've got your application in good time, but you're going through a very lengthy appeal process, and it can take many months, even years, for some of these technical details to be fully worked through the appeals process, it does seem somewhat unfair that that company would be unduly penalised, and that's without even taking into account the knock-on effect on New Zealand energy consumers and the wider economy. So we simply can't afford, sir, to have an energy resource, a gas field that produces 20% of our domestic supply, to have any uncertainty over its operation. And for this reason, I welcome the support of other parties in the House. I also need to note, sir, that this bill doesn't change anything for other operators. Those who have their existing permits and consents in place will continue to be able to explore and extract until their applications are further decided. If the amendments weren't made before the 27th of June, then Shell Todd Energy would have found themselves in breach of the 2012 Act if it was operating without a marine consent. So it's very timely that we're passing this legislation. In fact, one might say we're even getting it in a little bit early before that final deadline. So, sir, this is an important piece of legislation. I welcome the cross-party consensus on this, and I do commend it to the House.